You know, I'm sure everyone that's on here has been to one of our webinars before, so thank you for attending. As I said, we're bringing back Elaine Page, award-winning paralegal recipient of the Ontario Paralegal of the Year. You know, we had her on for the month of April. Once when COVID-19 hit and eviction, there was a moratorium on evictions wise. You know, we had a lot of panicky landlords. How do I deal with the situation? What can we do? You know, what happens if my tenant doesn't pay? Those kind of things. Well, we've made it through the spring and summer. Now we're into the fall wise, and we thought it was a great time to recap wise as we see the number of rental listings start to increase. Peak rental season is August wise, and the number of leases that get done after August goes down substantially. August in 2019, if we use it as a metric, 1,750 in downtown Toronto. September it drops down to 1,100, October 1,000, November 900, December being the slowest 800. So we definitely want to talk to landlords, help educate them, and prepare them for the winter months and what they need to do. And then below me, we have co-founder of Remax Wealth Builders Real Estate, Kyle Levigi. So we're all going to have an interactive discussion wise about tenants' rights and everything like that. So Elaine, why don't we start with, you know, I know 184 is going to be a big discussion, so let's do 184. We won't start off with 184. I think what we should start off with is we'll start with, okay, evictions wise. So evictions have restarted again at the landlord and tenant board. So why don't we talk about when those restarted approximately wise, what your experience has been and what the wait time has been for landlords.
Sure. So the Landlord and Tenant Board has started operations again. The hearings are all virtual. There was something to the tune of 11,000 cases waiting to be heard, and they are slowly but surely getting heard. So it's a crazy place. Like, I have applications for things like unauthorized occupants where we issued them in December of 2019. I still don't have hearing dates, but things that I've issued for non-payment in March and April, I am now getting hearings for. So right now what's going on is the board is doing a push to get all of the backlog dealt with. And they're starting to like really majorly push. So for example, in the first week of December, I think I have 48 hearings. Wow. For arrears of rent. And so those are the ones they're pushing hard on and trying to get them cleared up. They've also started doing case management hearings on a lot of things. So there's two sort of avenues. If you've got an application in the system, you've already made a deal with your tenant, you just want a mediated agreement, or your tenant's left, that's one avenue, and those are being expedited. And if you're waiting for a hearing where your tenant's still there and they're still not paying, that's another avenue. But it's happening. The sheriffs are working. I've had several evictions over the last couple of months, and there's a change in Bill 184. So which I'm going to go through in more detail, but as it pertains to hearings, if any of you have hearings that you're waiting for, I'm going to tell you to do two things. The first is notices are coming by email, and sometimes people aren't getting the email. So go on to the Landlord and Tenant Board website. There's a way to check your file, and you put in your file number and the rental postal code, and it'll tell you the status. And the other thing is, under 184, if you haven't tried to negotiate a payment agreement with your tenant in the past before the hearing, then your application may fail. So I had warned everybody in April. I said, start doing that. And not that I had knowledge that they're actually going to turn it into law, but it was a good common sense approach. So it is law. And if you don't do it, you might find yourself at the short end of the stick.
Yeah, and that flows into the next comment when and Lane and I were talking about what we're going to talk about today, working with your tenants wise, if you go back to any of our videos in April, we're like, work with your tenants, work with your tenants, work with your tenants. Still preaching the same thing. Work with your tenants, work with your tenants, work with your tenants. If you listen closely what Elaine said, applications she submitted in March and April, which 7 months ago, are now getting into hearings into November and December wise. That's 7 to 8 month wait time. And if you go back to our April videos, that's Elaine roughly said you're going to be waiting 6, 7, 8 months if you file this application for non-payment wise. They are expediting things, but you will be waiting for a period wise. And during that time, if they're not paying rent, you're going to be not getting any money in. So very, very important to work with your tenants. And we understand, we 100% understand there are tenants that will not pay you. And those are the issues that you really want to get down to and deal with those tenants wise and get the application in right away. Because if you're dealing with a non-paying tenant that is not going to pay you, that is a very serious issue that we have to deal with wise. But you want to try to work with your tenants to start at least getting some money in. And I can say we've seen a lot of success with that over from April onward. And I know even for one of my units wise personally, I always got rent on it, but one of my units, my tenant came back to me and very, very common. It's extremely common. Tenant goes, hey, you know what? My lease currently says this. I'm month to month. I don't want to pay that anymore. I want to pay this. And basically I'm like, okay, because there's not much more that I can do. And we agreed upon the lower rent. But one thing I wanted to mention to people wise, and this is important, is that you can do that as a temporary rental reduction wise. So you have the ability to reduce your rent. So I'll give my straight up example wise. So the rent my tenant was paying was $2,300 per month. They came back and said, I want to pay $2,000 per month. I said, okay. Now I didn't do a temporary rent reduction because my property doesn't have rent control. So I just easy wise, you know what, you want to pay $2,000, that's fine. Moving forward, month to month, you can pay $2,000 wise. She didn't want to agree to another 1 year term lease. I said, that's fine. Just pay me month to month, $2,000. But if you were in a rent controlled building wise, and what a rent controlled building is a building built before November 2018, I would strongly recommend that you look at doing a temporary rent reduction. So what a temporary rent reduction means is that, okay, you're going to agree to the tenant, you're paying 23, you want to reduce your rent to $2,000, no problem. I'm going to reduce your rent down to $2,000 for this set period wise. The key thing is that period can't last longer than 11 months, correct, Elaine?
Absolutely.
So if you go past 11 months, then if you go for, let's say 12 months or longer, then at that point, it will become the new rent wise. But you can temporarily reduce your rent for a period up to 11 months, and you'll be able to revert back to the old rent that is in your lease agreement wise.
Right. And the thing you're absolutely right, Alex. And the thing I would sort of mention to people is, in case you haven't heard this, there are no rent increases allowable for 2021. So it really is important to keep it to your 11-month max, because if now that you can't raise the rent and you have lowered the rent permanently, you're going to find yourself in trouble down the line in a year from now or 2 years from now.
Yeah, 100%. So again, if I go back to my case, I was fully aware that I can't raise my rent in 2021, but I also know that I'm not expecting a significantly improved situation in 2021 for my rental amount. So I just left it as is. Less headaches for me, wasn't that concern wise. But again, if you are in a rent controlled building, you definitely have to think to 2022, 2023, because let's say you're in a 1-bedroom, we see it, you're in a 1-bedroom and you're like, I'm just going to lease it for $1,600 per month. Well, when that rent jumps back up to $2,000 per month or $2,100 per month, your rate against the market is significantly less. And now, is that tenant going to leave? Well, they may leave for change of life situations or that kind of thing. But in regards from a cost level wise, there's going to be no motivation for them to leave because they've locked in until they decide to leave, that lower rent for the foreseeable future wise. So that's very important. If you're a rent control building, you do want to watch what you're going to be charging for rent wise, because that could impact you and bite you in the butt in the future wise, significantly wise, in regards to the rental revenue coming in. And the only way to resolve that is if the tenant leaves, or if you move in personally for 1 year. Don't mess around with that. Elaine, do you want to school people right now about misuse of the owner-occupied situation? Because I know that is the biggest complaint that you see. Always good to have PSA.
Yep. Yeah. Well, the increase in fine is $50,000, plus you'll end up potentially paying a year's rent back to the tenant, plus a difference in rent between your present unit and what they're moving, plus moving expenses. So it could cost you $80,000-$90,000 quite easily if you decide that you want to try that. Yeah. Not a good choice.
Don't give and cash and all the headache that you're going to have to deal with dealing with that wise.
Absolutely.
And Elaine can't help you out. it's pretty black and white if you say to the tenant you're moving in and then you rent it out 1 month later. There's really no getting around that. So wanted to just give everyone that PSA there if they think that if that's a workaround for them. That's a big red flag. So you know, we've touched base on those things, working with tenant wise, and I'm telling you, write this down about the rental reduction wise. I've personally had these inquiries. I know Elaine has. Actually, Elaine, I know I reached out to you. What is the best way for someone to document this, a rent reduction wise? Just an email wise?
What I would do is an email is fine, saying we agree, and note the rental address, note who the landlord is, note who the tenant is. Your rent is, I know it's not, but $1,000 a month. We have agreed to reduce it from the period of November 1st, 2020 to September 30th by this amount. But after that, so just do it in an email and make sure it's spelled out very clearly.
And when individuals are dealing with new leases as well, they're in these the Ontario standard lease, there is a section in there when you're writing a lease to do a rent reduction for a period wise. You can write it right into the lease, the very, very black and white section wise. Again, you can't go over 11 months, but you can do that in your lease wise. So again, you could lease your unit for $2,300, but say you're going to reduce the rent to $2,000 for the first 11 months. The 12th month, it'll be $2,300. That is in there in the lease agreement, fully legal, fully transparent wise. You can do things like this in your lease agreement wise. But when you're dealing with an existing lease, a very well documented email, as Elaine just described, you can do that. There is no specific form for that. You would just do up an email that clearly states those items there. So something important for everyone on this call. So let's get into Bill 184. I can say personally, I don't know much about it. I just know it's called Bill 184. That's about the extent of my knowledge wise. And it was passed over the summer. So why don't you talk about what it is and the impacts for tenants and landlords?
Sure. So Bill 184 is also known as Protecting Tenants and Strengthening Community Housing. And it has all sorts of implications across the board in terms of building permits, etc. But what pertains to us, I'm going to go through. But before I do that, I just want to explain how the parliamentary system works. So a bill is put forward, Bill 184. It goes through 3 readings, and there's debate on about it, and things get changed. And then finally, it reaches something called royal assent. So on July 21st, 2020, Bill 184 reached royal assent. And that means that it's been passed into law, but it is effective on the proclamation date. So when you're reading the Residential Tenancy Act now, you'll always see things like on the day that this becomes proclaimed. So part of 184 has been proclaimed, and this is why people are so confused. There are pieces that are proclaimed in our law as today, and there are things that are not yet proclaimed that we're anticipating proclamation like in the next 10 minutes, anytime now. So I'm just going to give you a real quick overview on what that looks like. So some of the things that have not yet been, have not come into law yet, but as I say, in the next 10 minutes, that could change, right? Is around compensation for purchaser's own use and the process with which you do own use applications as well as purchaser's own use. So there's an affidavit or a statutory declaration required. We used to just file those on the day of the hearing. They now have to be filed with the application when it's issued. And I make it a habit to do that anyways, because I don't want to get caught in no man's land. So when I file it all. There's compensation changes on terminations for demolition and conversions. There's compensation changes for termination for repair or renos. The big one is the bad faith application. So that's what we were just talking about, which is when you say I'm going to move into the unit for a period of a year and then you don't. There's huge, I mean, there was always big penalties, but now there's huge penalties. And if you're a corporation and you try to do something of that ilk, you're looking at a $250,000 fine. So the design was to stop the rent evictions. This is the whole point, was people were taking advantage of these sections of the act, and you see the rent evictions happening. And this is designed to stop those and to have landlords heed warning that if they're bringing that application, they better be damn serious. So those applications are actually tougher to get now because the bar is that much higher. So the one that you've kind of heard about the most and has got the most confusion is these non-payment of rental applications. So right now, the way that it works is I issue an application, and if I want to make some kind of deal with the tenant, if I put it in writing and say we're done, it's not binding. It has to be done through a mediator or on a consent by an adjudicator. So the change is that once I have an application issued, I can make a deal with my tenant. There'll be a form, there'll be a process, and then it goes into the board and it becomes an official agreement. And if the tenant fails, I can, without notice to the tenant, go back to the board and say, this individual said they were going to pay $1,000 on December 1st. They didn't. And now I want an order, and I will get that order from the board. So that's the change. So when you're negotiating these agreements that we talked about before, when I talked about it in April, it's still the same. My recommendation in this moment is to issue applications. You can always make deals, but it's a question about whether the deal is binding or not, because there's no application before the board. So that's the big thing that's confusing everyone. It's why the tenants are all going crazy, because they have this belief that we can somehow fast track an eviction without them having any recourse, that they're lay people, they don't understand. And that the landlords are taking advantage of them. There may be a little bit of truth to that. I'm not sure, but let's also say that, let's say I did an agreement with a tenant. They failed on that agreement. I got an order terminating the tenancy. The tenant would be notified, and they do have an opportunity to bring a motion to the board to explain why they didn't pay and to seek some kind of relief. So there are built-in protections. The tenant advocate groups don't believe the built-in protections are strong enough. And I guess it remains to be seen. I don't know until we start actually doing them. So that's a big change. The other big change for you that'll impact you is, at present, we really can't go after hydro utilities as part of an application before the board. Under Bill 184, when this piece becomes proclaimed, We actually can go to the board on hydro and water and sewage and all that stuff. And the other thing is that, and we talked about this again in April, around this problem around where does the landlord and tenant board's jurisdiction end and where does the small claims court's jurisdiction begin. That's now been clarified, again, not yet in force, but any minute now. So if you have a tenant that, when it's enforced, if you have a tenant that skips out in the middle of the night, you can, and they left with all of these arrears and you had no application at the board, you will be able to go after them at the landlord and tenant board. Same with if there were damages to the unit before you had to go to the small claims court, now you will be able to go to the landlord and tenant board. But you got to find the tenant first. So part of this is that you're going to have to personally serve the tenant, which is one of the reasons that I say up front, the more information you have about your tenant, the better, in case you need to track them. Driver's licenses are great because eventually somebody will change their driver's license. There's a limitation though. You have 1 year to go after these people at the board. It remains to be seen, because it hasn't been tested, if that 1 year expires. Generally the statute of limitations is 2 years in all other courts. So it remains to be seen whether, if the 1 year has expired and now it's 1 year and a day and we finally found the tenant, whether we can bring that to small claims court. I don't have that answer. It is on the small claims court radar because I brought it to their attention. And it'll have to get tested. So those are the big kind of big view of what the changes are.
Great, perfect.
Elaine, I have a question, Elaine, actually. If you were awarded, say, damages by the landlord and tenant board, how do they actually enforce that? Is there a mechanism there? Can you just talk that a little bit?
Sure. So anytime you've got any kind of order from the landlord and tenant board, the enforcement arm is the small claims court. So that doesn't mean that you have to start a file at the small claims court and relitigate, like go in front of the court and argue for either the arrears of rent or the damages. If you already have the order, there's a process to open a file at the small claims court and to do enforcement. Now I say that, except that in this time and in this moment, the small claims court is very limited in what they're doing. And that's a whole other, that's a whole other thing. So hopefully in the next few months, we'll start to be able to do those sorts of enforcements.
And I think then, you know, when I've dealt with people and there's a tenant that they want to seek some reimbursement from for leaving early or those various things, I find the landlords, they're not as concerned about the actual getting the money. They want to make sure that the tenant can't get away scot-free, and they want to make sure there's some sort of penalty against the tenant wise. So just for them to know, if they were able to get that order on the landlord and tenant board, then they have it, the small claims court can then go to enforcement, and now there is some sort of record of that non-payment wise. That would satisfy a lot of the landlords out there going, okay, I've marked that person. Yeah. They've been marked, that now that is on their identity. I feel good about that. Will I see my money? I don't know. You know, it'd be great if I did, but I know that they didn't get away scot-free.
Yeah, like I have one right now where the sheriff will probably be coming in the next couple of days. The guy is $34,000 in arrears. He's working. I know where his bank accounts are. I've confirmed and verified he is still, I'm not going to say what because I don't want to identify him, but he's still a big shot. And I fully intend on garnishing him the moment that I'm able to, because he's been doing one of these at us, and that's unacceptable.
Yeah, like, no, for sure. And I would say if someone was $34,000 in arrears, I take back my past comment. My landlord will want that money.
Yeah, but you know what? If it's, a month's rent,
Yeah.
like it almost isn't worth doing, and the hassle that is involved in it. I mean, each case is different, but you're right. Once you put it into the court, it's a court order, and it shows up on credit bureaus. It shows up in all sorts of places. So it will be a mark on their name.
Yeah, so that it's great to now have that answer, because we get that question a lot going, what can I do? What can I do? There is a recourse now. It's not a nice road, but at least it's a road if landlords choose to go down that they can. So that's great. Kyle, is there any other questions that you want to ask, or should we open up the floor to some questions wise to everyone?
Yeah, no, that was actually the most common question that I got is how can I enforce these? What can I do to get my money back? So that answered it. Thanks, Elaine. So let's open it up to the floor.
Okay, let's go to the Q&A. See, we got at least 2 things in there. Okay, great. Elaine, you're able to open the Q&A, right?
Yeah, yeah.
Okay, so I'll just read it out to everyone, and then Elaine will get in the question. Hello, my scenario is the following. I signed a renewal lease with my tenant where we indicated that for the next 12 months, the rent is less $100. The term is September 1st, 2020 to August 31st, 2021. We made a written note at the bottom that as of September 1st, 2021, the rent will go back up by $100 or more. The tenants gave me the checks for a year. What should we do considering I have the checks and we signed for the next 12 months? So it sounds like they did the 12-month one.
Right.
So what are your thoughts on that?
Well, it sounds like the person who wrote this question has a really top-notch relationship with their tenant, that they were able to come to this agreement and the checks were tendered. We can't go back on this agreement now and say, oops, my bad, I want it to be 11 months. I think that at this point, all you could do is just to write to them and confirm, I mean, that they should anticipate that the rent will go back up, that it is not a permanent reduction. And it sounds like that's already in there. You know, it's hard to know. You can't undo this. So
yeah. And what we say is our advice, we check, this is the letter of the law, right? It doesn't mean that the increase can't happen in 12 months. It's just if the tenant calls you out on it and does their homework, they could refuse it. But if you guys continue to operate in your own relationship wise, it can 100% be done. It's just that if they push back, they do have recourse on that. But if they don't do anything, then you'll be okay. We just tell you what the letter of the law is to protect you in case something like that happens. So again, if you are offering some sort of reduction to everyone on the call, 11 months, not 12 months. But if the tenant doesn't push back, then you're okay. We're just trying to protect you in case they do. You know, Sal just asked a question here. You indicated once in court, is that small claims or LTV where their credit score will be impacted? How does this work?
That's a great question, Sal. It's a bit of a mystery to all of us. Generally, there is a relation. I don't know about the landlord and tenant board, but I do know with the court, there's generally a relationship between Equifax and what's the other big one?
TransUnion.
TransUnion. There is a relationship, and there is some kind of data exchange between them. Nobody at the court has ever been able to tell me specifically. I have asked many times. So it's not 100% that if you have an order in the court that it'll get on their credit. There is a good chance that it will, but it's a mystery how it all happens. One of the things that some of my landlords have done is put it on, if they have an existing relationship, if they're a member of one of the bureaus, they can actually put it on themselves. Another way to get it onto the bureau would to send out the order for collections. The collection agencies generally will put it on the bureau for you. And there is an organization that has started up, and I honestly don't know anything about them, so I can't tell you one way or another whether they're good or bad. They're, I think, either out of Alberta or BC, And it's a registry for landlord and tenants. It's called like the Landlord Credit Bureau. So if you're I think the idea is if you're a landlord, you report every month whether your tenant paid on time, and that boosts their credit bureau. Conversely, if they haven't paid, it lowers them. And then as a landlord, you can, if you're scouting for new tenants, you can put them through that system to see if there's any registrations. I really don't know a lot about it. I'm not recommending it. I'm not saying it's not, I'm not recommending it. I don't know enough about it. I just know that it exists.
Just something people can investigate if they want to.
Yeah.
And I want to add another thing too, just talking about credit reports, and because I'm in the weeds, Kyle's in the weeds, we're on the ground when we deal with this. We never accept a credit report that someone provides to us, because that we still ask for it. It's great. You give it to me and that's already bad, then it saves me an extra step. But that's not our final due diligence. We always have our own credit reports run.
That's smart.
As an individual landlord, I don't know how that's done. We actually have access to Equifax through our office. We have an account and procedures we have to follow wise. So I don't know how an individual landlord runs their own credit report. But we always run our own credit wise, because, you know, Elaine, speaking about that piece of paper, with technology these days, very, very easy to manipulate that piece of paper wise. So we always run our own credit reports. And number two, always validate employment data, and go to Google websites. If someone says they work for,
Excuse me,
go to call ABC Corporation, Google ABC Corporation, use that phone number, and then ask for that person in the company wise. Don't rely on the number that's provided on job letter wise, because again, that could just be a made up number saying, hey, if someone calls you today, just answer as so-and-so. You know, do social media looks like, look at LinkedIn, those kind of things. These are just little things that'll help you avoid getting a, what word do I want to use?
Scammed.
Well, scam. Yes. Yeah. There we go. Just scam. I was thinking I'm going to say something else, but scam. You don't want to get scammed. Scams exist out there. And in times of crisis wise, there are lots of scams out there where I talk to my fellow realtors and just, they say, hey, watch out for this person. This is a fake application going through, that kind of thing. So
we've seen it ourselves. We're running our own verifications where the credit scores have been falsified. You know,
I've seen it too. I've seen it after the fact. So somebody's moved into a $4,000 unit. On paper, they look great, and they stop paying the rent. When we start looking more carefully, it's all made up. So that, just to come back to something you said, this is one of the recommendations I have is to make sure you have government ID with the proper legal name of your tenant, because you know, you can look them up on LinkedIn, and if they identify themselves as Chaz, and you look up Chaz Smith doesn't exist on LinkedIn, but Charles does. And so, I mean, that's an easy one to figure out, but not all of them are that easy. And some people use their middle name as their first name. And so make sure to get, like, to have proper government ID in your screening process.
Yeah, that's actually a great point, Wise. You know, Toronto's the most multicultural city in the world. There are individuals on their LinkedIn profile will anglicize their first name, but their actual legal birth name is different from their anglicized name, and there could be some conflict there. And that person could be, you know, a VP from some sort of company. They have their first name anglicized, that kind of thing. So I think that's a very, very relevant point. So again, common sense and due diligence wise, really, if you do those things, I can say I don't think you'll get scammed really if you do the due diligence wise, because if someone is trying to scam you and you start raising red flags, they're going to run away and just stop communicating with you, which is a good thing, which is a great thing. They're not going to try to fight you back if there's some issues that you're questioning them on. Now, I don't know the answers to the next one, Wise.
From Sandra. Hi, Sandra.
Yeah, Sandra.
Nice to hear from you. Yeah, Sandra, you can't, Sandra's asking about tenant updating information work or otherwise on a regular basis and asking how to enforce the covenant. You can't. There's no way to do that.
Yeah, so I'm gonna answer this because when I didn't think there was, but when you mentioned it was in the lease, there is only one lease. It's the Ontario Standard Lease. Everything else is just words on a piece of paper. So you may have written down that they have to regularly update you their information, but legally, do they have to regularly update you their information? No, they do not. There's only one lease. It's the Ontario Standard Lease, and that is what's legally binding. The other items aren't legally binding out there wise. So I didn't think that was the case, but it's good to confirm that. So there is no recourse. You can't have them, validate their future employment, that kind of thing. So here we go. Another question here. The last month's rent question. Can the tenant ask the landlord who's behind on their rent to apply one of their missed monthly payments? Can the landlord say no and only hold the last month for when they move out? Yes. Yeah. The tenant can ask, and you have the right to say no. That's
yeah. And as a matter of fact, I have had a lot of people over the last few months, particularly, use the last month's rent deposit as a month that of rent, and it's actually incorrect to do that. Last month's rent deposit is exactly that. It is for the last month of tenancy. And then if you have done that, make sure you get it in writing and let the, something in writing confirming that the tenant no longer has the last month's rent deposit, because that tenant may stay for 4 or 5 more years. And then thinking that they're forgetting completely that they have used their LMR, and then, you get into this dispute down the line. So just put it in writing, but I don't recommend doing it anyway.
No, we do not recommend it either. And I'll give you people a different example. So a tenant gives you, okay, just use my last month of rent this month, and I'll catch up next month. Then at the end of the month, they leave. And that's what happens. We're getting a lot of short notices from tenants to be vacating their properties these days. That's what your last month is for, to protect you against that short notice wise. Once we lose that protection, again, the tenant can leave November 30th, December 1st. You're like, where's my rent? And the tenant's like, I'm not there. Or tenant's not going to reply to you. Tenant's gone. You're going to go to unit going there. Hey, there's no one here anymore. And then we start the process to re-rent out the unit, and you're going to have a vacancy expense. So never give up that last month. We highly suggest against it wise, because the pitfalls are just too great on that. So.
Right. So Sandra's asking that again about the covenant and about section 15, and wondering why it can't be enforced. Yes, I don't have section 15 in front of me, but the reality is you're not going to get an eviction based on the fact that your tenant won't give you updated information. That's the only time that might happen is if there's a requirement under the lease, and I would assume that there would be, to have insurance, and the tenant doesn't provide you with current insurance. We have actually evicted people for that reason. But because the tenant doesn't, they may be required to give you that information, but there's no teeth to it.
There you go. Perfect. Good answer there. And Elaine, we got another question here. How do you ensure that the tenant cleans the unit after they leave? I rarely have tenants clean the unit, i.e. they leave food behind in the fridge, floors damaged. Is there a way to bill them for cleaning the landlord has to do before the next person moves in? I haven't had any luck with it.
The court has consistently said, there's normal wear and tear, and then there's damage. And the type of issues that are being asked about within the scope of this question is normal wear and tear. And the courts have consistently said it's the cost of doing business and have not made any awards. Now, if there's damage, that's a whole other thing.
Yeah, and I'm gonna answer this question why. So let's say the cleaning is $200. The amount of work you would have to do to try to squeeze that $200 from the tenant wise it's probably going to cost you about $1,000 just to do that, plus time-wise just to get that $200 from the tenant-wise. So going back to Elaine, it ends up being a cost of business-wise. But we're just, can you force them to do it? No, but can you stay on top of them and just consistently remind them? Yeah, 100%. So I just say staying on top of them is going to be your best way to be proactive to try to get them to do it wise. But again, is there any way that you can hold them to it? No, you just hope they're a decent human being. That's what it is.
And the cleaning is an expense and write off in your taxes anyways, if you have to go that route.
Yeah, and here's what it is. Let's say the tenant, I'll put it in clean the unit, okay? They clean the unit. The new tenant moving in, it may not be the standard of cleaning for the new tenant moving in. So we always get our units professionally cleaned. It is a bit of a hassle come that you have one moving out, moving in, and at the end of the month wise. But that way, by getting it professionally cleaned, I have a clean slate for the new person moving in. Or even if my timing doesn't work exactly getting that professionally cleaning done, I've said to the new tenant, hey, you know, just timing wise, you got one moving out, you got one moving in. We'll be sending someone in to clean in between wise. You're starting off the new relationship on the right foot. So to rely on the professional cleaning of the outgoing tenant. The other way you could potentially do it as well is, again, helping organize the cleaning for the outgoing tenant wise. So saying, hey, I have a cleaning company wise, you can pay the incoming cleaning company to clean up the unit once you leave. You know, again, is that a requirement? Do they actually have to go through with that? No, again, they don't. But if you make it easier for that to actually be done, remember, moving is one of the most stressful things that humans can go through wise. That tenant moving out is already stressed. So if you can take that cleaning off their plate and they're just going to reimburse you or start a relationship that way, that's something that you can help. So again, there is no perfect answer with it. But again, constant dialogue, being proactive, helping that tenant that's moving out organize wise. Remember, they're going through a stressful situation as well. If you can help them with that, that'll help alleviate some of that. So we have another question coming through. Hello, I serve tenants in N12, but it turns out they went back to their home in China without informing me and without moving their belongings. And they are not allowed back into Canada due to COVID travel restrictions as they are not Canadian citizens. They refuse to make arrangements to move out their belongings or to agree to my doing so. They say that they will move out whenever they are allowed back in the country and are still paying rent. Under these unusual circumstances, doesn't eviction seem likely to be successful? I'm going to back up though. They're giving you money? That's what I heard, right?
Yep.
That's great. They're giving you money. Fantastic. But Elaine, I'll let you jump into that question wise.
Okay. So I don't want to comment on the specifics of a case that may be before the board. I will say this though, generally the N12 was served for either the owner's own use or the purchaser's own use. If it's a valid N12, in other words, you didn't screw it up, and it's what we call a bona fide it's a bona fide application. I don't see why it wouldn't go through.
Oh,
especially since it's a virtual hearings now.
Oh, so N12 is the owner move-in wise.
Yeah.
Oh, I'm sorry. So Adam, I apologize. Why? Sorry, I didn't realize. I had a brain fart there about the N12. So yes, that is an unfortunate situation where you can't. That's very frustrating. You can't move into your own home wise.
But honestly, I mean, I would say this: it's no different whether they're here or not. You're waiting for. I'm assuming you've issued an L2 application, and that in your N12 is fine. There's no defects on it. Now you're just waiting for a hearing. It doesn't matter where in the world they are. The hearing is going to come.
So Adam, I will sympathize back to you. This happened to me, not someone from China and removing their belongings, but the house that I bought, and that's how Elaine and I met. She assisted with my situation. I bought a house and we fully planned to move into it, and there was tenants there. And when we got the house, tenant said, I'm not going anywhere. And we were homeless. The N12 that was issued to the tenant wise by the seller was incorrectly done. We had to wait until we got into our home. Now, it ended up, Elaine was able to negotiate for us, and it didn't end up being as long as it could have been. It ended up only being 4 to 6 weeks. And we had accommodations that we could stay in. That wasn't an issue wise, but it can be a very stressful situation. So I would say that depending where you are in the situation wise, you may want to seek some professional help on this, because we've mentioned this in our April videos. If you've done the form wrong, it will get thrown out immediately wise. Remove common sense going, oh no, but you know what I was trying to say, right? They don't care. It's filled out wrong, gone, restart the process wise. Been through it personally wise, that's what's going to happen. So you want to make sure it's all done correctly. And I sympathize to your situation. I was homeless, and there's nothing more frustrating. You own something, you're like, that's my home, and you can't move into it. So you may want to seek some professional advice to make sure things were done correctly if you have not done so already.
Yeah, and I just want to add in one little comment, which is a lot of real estate closings have failed now because they were contingent on vacant possession, and because of the board shutting down, and no hearings happening for an extended period of time, we have a lot of deals that has now fallen through. So if you're in the process of selling your rental property, and I'm sure Alex has a few things to say about that around the timing of it and all that, make sure you leave yourself enough of a closing time. And I'm going to tell you, 5 months closing, which seems like an astronomically huge amount of time to close a property in this day and age. But you need it if you're promising vacant possession. In order for us to go through the process, that's the bare minimum.
You know what, and I'll add this, and Kyle and I talk about this consistently. Why? So let's talk about selling tenanted properties. Most likely a property is not going to sell with a tenant in there. A, it's not going to show great. B, listings are up over 300% if we're dealing specifically in the downtown core wise. So if I'm a buyer's agent or a buyer wise, why am I going to go look at someone with a tenant wise? I'm going to look at something that's owner occupied or vacant wise. So that's number one. Number two, those issues that Elaine just mentioned. Now, not only does the property not look great, do I want to expose myself to someone that could be there, that's working from home, that kind of thing. Oh, and that person may not leave. Well, that's not good. So what we advise our clients is the only time you should be looking at selling your rental properties is if the tenant gave you notice. That provides you with some confidence that that tenant is going to leave. And then most likely it's probably not going to sell for the price that you want until after that tenant's gone. But to sell a property with a tenant that's currently month to month, that has not given you the notice that they're actually going to leave the property wise, you are asking for problems wise. So it's not, unless you're in dire straits and you need to sell a property, we would advise you now is not the time to sell the property. It's time to bunker down. You're getting your monthly income coming in. That's something that's good right now. It's not going to be something that you want to really sell. But if it's something where it's coming up, the tenants gave you notice and you don't want to deal with a vacant property, you're worried about it sitting empty for a long time, then yes, then there's things that we can do with that. So you don't want to sell a tenanted property right now if the tenant has provided you, if the tenant has not provided you with proper notice wise. And I'll add one more thing. The lines that we get from tenants, Kyle was talking to me about it yesterday, and I was like, we've dealt with it many times. The lines that we get from tenants do not want people coming through their properties. And the stories that we get today from tenants going, I'm going to cancel this showing, I'm going to cancel that showing because of this, because of that, because of this. They should be writing books. They'll be in the New York Times bestseller list because the stories are so good. So
very creative.
Very, very creative stories wise. And these are from tenants that are still going to be leaving the property. They've given notices. So can you imagine the stories you're going to get from a tenant that hasn't given notice to leave the property? So anyways, just some 2 cents about the reality of the situation.
Yeah, people are scared. They don't want strangers wandering potentially exposing them to the virus by leaving trace amounts of the virus in their property. So, you know.
Yeah, it's all completely
Even pre-COVID, I saw significant benefits to selling a unit that did not have a tenant in there. I had a client actively looking, and he really liked 1169 Queen Street West. We saw one property that was tenanted, and we saw the exact same unit 2 floors higher that wasn't, and it was staged nicely. There was a $35,000 difference between the selling prices of those within days of them selling. So you're giving up money by selling a tenanted unit because you can't get in there. You can't maximize the value on that property by staging it, by doing the repairs, by not having a tenant in the unit.
Oh, 100%, 100%. And
yeah, sometimes the tenants don't want to move, so they'll say, "Oh, it's a great building, except when the elevator crashes every other day," or
had that before. Yep.
You know, or whatever. Oh,
Yeah.
yes, we had a leak, and there's probably mold in the walls, and you know,
the
we hear all
neighbors are
sorts
noisy, or you know, people down the hall are cooking funny smells. Like you hear again, they get very creative.
You're very creative. So again, these are words from the street. I like Sal's question, Elaine. I really like this one. It's a good counter to our last rent. Wouldn't the landlord tenant board court say you didn't work with a tenant if you said no to using the last month's rent if they're behind on rent? Wouldn't the impression, there we go. So Elaine's saying no. Good.
No, because the board will just say straight out, last month's rent deposit is to be used for the last month. What the board wants to see is some kind of offer for a repayment plan, or, you know, some people on CERB were not getting CERB on the first of the month. They were getting it on mid-month. So they delayed, allowed the tenant to delay paying the rent till mid-month, that kind of thing. Now people are back to work. So, all right, you're $5,000 in arrears. Your rent's $2,000. Can you do $500 a month extra in order to catch up? That's what they're looking for, not playing with the LMR.
Perfect. Great. And again, landlord and tenant board, very black and white. So they view strongly on that, what that last month deposit is. And
excuse me.
But I want to add something else because we did talk damages. Again, in Ontario wise, there's no damage deposits, not allowed. Just say that for a PSA to everyone. Sandra, back again. If a rented house is sold and the buyer wants personal use, who gives notice, the seller, landlord, or the buyer who wants the home personally?
The seller gives the N12 notice on behalf of the buyer. And Sandra, if you have that situation, I'm going to recommend that you either call me or a colleague and let us do it for you, because it can be complex.
Yeah, and I'm going to add, yeah, you definitely, if you're doing that situation wise, and the seller is providing that N12, again, was in that situation personally wise, did not work out in my favor. Make sure you get all those documents sent to you as well, because you have a vested interest in those being done correctly wise, and you want those third-party validated, because these things can be corrected. They can be corrected. That's allowed. But if you don't know that there was a mistake, then you're going to run into an issue down the road.
Yeah, and so one of the things that I typically see is that real estate lawyers fill out the, you know, I spoke about the affidavit and the declaration, the statutory declaration. They fill them out, and they fill them out incorrectly. There's very specific language that has to be in that declaration. If it's not there, then the case gets tossed. You can't correct that. Like you know, you'd think that you could say to an adjudicator, listen, I hear you. Let me just go out let's just recess for 10 minutes and I'll draft it in my handwriting and get it signed and executed and come back here. And I've seen adjudicators say no to that, which is ridiculous as far as I'm concerned. But again, you know, it's a very specific language. And unfortunately, there are many, many lawyers who do practice real estate who know the language, but there are some that do not.
Yeah. And we're kind of coming up against 12 o'clock. So thanks everyone for asking questions, for spending this hour with us. I hope we helped everyone out. We'll be back again next week wise. So if you know anyone that wants answers to questions or wants a recap on this, we'll be back again next week. Elaine, thank you for taking this time, especially taking you away from the cottage. Go outside, enjoy the weather. We really appreciate it. And again, if anyone has any questions, you can reach out to Elaine. There'll be a recap email sent out to everyone wise. Kyle and I are also here to help with your rental property. So everyone, thank you so much. We'll talk to everyone soon. Bye, guys.
Thanks, guys. Be well. Bye-bye.